On September 15th, 1994, this is one of a series of interviews with members of the Nebraska Broadcasters Association Hall of Fame. Steve Murphy started his career with the WLW stations in 1948 and retired as news director in 1990, although he continues to work part-time for the stations and continues to be in charge of Freedom of Information activities for the Nebraska Broadcasters Association. In the conversations that we have today, it's probably worthwhile to emphasize the Freedom of Information, First Amendment activities. Probably nobody has done more for freedom of information for broadcasting in Nebraska than Steve Murphy. So Steve, what kinds of things come to mind? What cases, what issues come to mind when you review broadcast journalism and freedom of information in Nebraska?
Well, first of all, I guess I'd have to, without appearing to be overly humble, say I don't know that nobody has done more. There are a lot of people who in the trenches and who are working hard every day, whose efforts to advance freedom of information don't come to public attention. Well, you know, I guess an answer to your basic question, it all comes under the heading of access. And in Nebraska, the efforts to prevent access to public information have generally occurred in the areas of law enforcement people, sometimes either not acknowledging the existence of the state's public records laws, or perhaps not being aware of them, or being careless in seeing that they're carried out, and there are difficulties for reporters in some of the communities, particularly some of the smaller communities, in getting the information that the law says that they have a right to and the public has a right to. It comes under the heading also of access to courts. In Nebraska, we, after many years of struggle, as you know, Larry, now have access to the Supreme Court and the Appeals Court. When I talk of access in this instance, I'm talking about camera and microphone access. We've always had access in terms of going in with a notepad and a pencil and recovering a trial. So the struggle goes on to get it also designated for the state courts and the lower courts. And then also another access question is open hearings in terms of public hearings. City councils, school boards, legislature. Biggest problem, I suppose, across the state has been in school boards. Quite often school boards find ways to go into executive session and create problems for trying to get public information. In recent years, and I might just add this, I think that we've had some difficulty in achieving or calling attention to the need to public access, because the public itself hasn't always been supportive, and that's a whole new program that we could talk about for 2 hours, I guess, is the fact that the media itself is somewhat suspect now, and the public doesn't recognize or doesn't acknowledge the fact that when we are out there pounding the drums for public access, we're saying we're doing this because we represent the public. It's not a thing that everybody acknowledges.
Sometimes in your role as Freedom of Information chair for the Broadcasters Association, you have calls from somebody who comes to you and says, here's a problem, what should we do? What kind of calls have you come to mind?
Well, as I indicated, they quite often will come from a small station somewhere in the state, perhaps a young news director just a couple years out of school, or a year at the most, and he suddenly is confronted with a county attorney who won't release information to him, or a police chief, or a sheriff. Quite often it's, as I say, a typical example would be a sheriff would give orders to his people in his office that only he can release information about fatal accidents, crimes, or things of that nature. Well, the sheriff goes off and to go fishing for 2 or 3 days. And, there are a lot of things happening in town, and the reporter is in there trying to get it, and the guy at the desk says, I can't give that to you, you have to get it from the sheriff. So there's no acknowledgement in many cases of immediate access of the needs of reporters to have the information now. That news is perishable and time is perishable, and there's a certain feeling that well, you can have it when the sheriff comes back. I've often thought it sometimes grows out of the fact that a lot of these smaller communities deal with weekly newspapers, and so they think in terms of deadlines for weekly newspapers, and if a small broadcaster there is trying to get something for his next newscast an hour from now, it doesn't mean anything to the guy at the desk or to the sheriff who went off fishing.
You spent many years as a board member of the International Radio Television News Directors Association, so you perhaps have a perspective of other areas beyond Nebraska. How do such things as the open meetings laws in Nebraska fit into the national picture? How good are the open meetings laws in the state?
It's my impression that we're pretty good, with some flaws, but from what I know of other states, there are not too many who have any, I don't know of any who have any better law as far as open meetings is concerned. It's the implementation and the carrying out of it that sometimes is a problem. But I think Nebraska, by and large, starts out in the law with the assumption that everything is open, that courts are open, that meetings are open. That's the basic law. But the implementation of that is sometimes a problem because the word does not always get down to the people who are really making the decisions.
Sometimes when we talk about open meetings, we talk about the fact that that means that the citizen, not just the journalist, can go in and sit down and participate and watch and see the members of the county board of supervisors or the city council or whatever. But how about, in your experience, the issue of broadcast television technology, the film camera first, the video camera later on, being welcomed or not welcomed to those meetings?
Mm-hmm. Again, that's a question that in the courts it's been a particular problem because of the attitude of judges and some lawyers about cameras existing in courtrooms. I think there's 40-some states now which have some kind of camera microphone coverage in their courts. And for the most part, it's been successful. I don't think there's been any incident established where people have been denied a fair trial or denied justice because of a courtroom situation, with a camera in a courtroom situation. As far as allowing cameras in other kinds of meetings, city councils, the legislature, there are certain rules established, but by and large it's not a real problem. You may find an individual mayor or individual city council president who may try to ban a camera, but I think it's been pretty well established in this state as well as elsewhere that, except for the courts, the technology that we have to use in broadcasting is now acceptable in all of the public arena.
How about the transition from the film cameras to the video cameras? Was that a help or hindrance in your experiences?
Well, it was a help, and I guess for the most part. I'm trying to think now of any hindrances. There could have been some, but the basic thing about video cameras and tape is that you can set up the camera and let it run, and you're as we're doing here, and you're running tape and not using up film. I can recall an earlier day when film was so expensive that a news director would be required to report monthly on his film shot to film use ratio, to the front office, because you'd shoot so much film and you'd and throw so much of it away. Well, tape is not thrown away; it can be erased and used again. So, if that's your question, it's been an advance in terms of how it's used in in the meeting room or in the camera room, it requires less light, and it requires it's not noisy. It's very quiet, and so there are pluses there too.
When you first started out as a reporter in 1948, before you became a news administrator, news executive, news leader, and so forth, how do you get the impression or recall the individuals in society looking towards the broadcast media for information about the kinds of things that we're talking about here in terms of public meetings, the city council meeting, the county board of supervisors meeting, the state legislature, groups like that? How did that compare in 1948 with it was in more recent times, with the issues of technology involved, of course?
Well, you know, we like to say that we kind of invented television news, those of my generation. When I first started, we were doing radio only, and quickly went to television within a year of the time I started. We were experimenting to some extent, and the public was learning right along with us about what our capabilities might be. Radio came into its own as far as news is concerned, I think, during World War II, with in terms of public perception, with a great broadcast of Edward R. Murrow from London, and some of the coverage that radio did of World War II. Television was such a curiosity when it first started that, as we say, people would stand in front of department store windows and watch test patterns because just the idea of pictures flying through the air fascinated them. So, you know, it's we used in the early days a lot of still cameras. We'd go into a city council meeting with a speed graphic camera such as a newspaper reporter would be carrying, and shoot pictures in there. We did what we called radio with pictures. We were doing radio reporting, and then we were slapping pictures on there too. And the public, I think, as I said, was so fascinated by the new medium that it pretty much accepted anything you put on the air. Well, now the public is much more sophisticated, much more critical. As I say, if you can go to the moon, you ought to be able to do this, you know. And so, if you have the slightest error in technology, why people are very impatient with it, I think.
Let me ask you a comment on this particular kind of an issue. In certain times, when as a reporter you would go into cover a meeting, there may be things that would happen during the meeting, byplay or disruptions or other kinds of things that, as an editorial judgment, you just wouldn't report. But the issue is that if you are running a video camera and you are, as you've indicated, running it continuously so that the whole meeting is recorded, do you think that does have a particular kind of an effect on the way the meeting is conducted, or the people or the participants, the elected officials?
Well, you know, that's one of the arguments that people who oppose cameras in the courtroom make, that the lawyers will grandstand and that even the judge might be affected by the cameras. But from what I know, the evidence has been that it's not been shown that has had any serious impact on people's behavior in the courtroom after a while.
How about besides the courtroom? How about in, for example, an elected body such as the city council?
Yeah, I think politicians being what they are, there's bound to be, you know, some awareness of the fact that there's a camera there, because they, even though they become used to it over a period of time, and because it's real quiet and they are almost not even conscious of it, I think that's more likely to occur in the terms of people who are appearing before the council who are not really aware of the camera because they're not used to it. The guys on a city council or in the legislature, when the light goes on, they know what's going on, and I suppose that there may be some instances where they are playing to the camera. But again, talking about public sophistication, I think the public recognizes that too. I think that if a guy spends all of his time playing to the camera, I think the public recognizes it. And sometimes you can tell, you know, if a public official is talking to the reporter, or if he's in an assembly and he's talking to the crowd, that's one thing. But if you see him turning and looking directly at the camera, then I think you know that he's aware of it's there and he's trying to get his message out to the tube, no matter what the people out there think about it.
Now, you've also talked in terms of the relationship of the technology, the cameras and the microphone, to the judicial branch of government, the cameras in the courtroom kind of issue. And there have been some issues in which, over the period of time, that the attorneys for usually the defense have wanted to close a court. What kinds of things come to mind in terms of freedom of information issues in the state that relate to broadcast journalists?
Well, that quite often, yes, as you indicated, happens when a defense attorney wants to close. Usually it's a preliminary hearing before the trial itself. The reason they want to do that is they don't want, or sometimes the prosecution will want to do it too, because there's certain evidence that they don't want to have to put before the public in a preliminary hearing. Usually the defense will object to it because they say that anything of that nature will poison potential jury panel. So that's usually what it comes down to, is that they say close this preliminary hearing because if the public sees all this, we can't draw a jury. Well, you know, there are remedies for that. One is the change of venue, and they can go somewhere else for a jury, which has happened from time to time. But on balance, again, there's, I think, been studies showing that it's still possible to get an honest jury, no matter how much publicity a case has had. And we're certainly going to, the time that we're doing this interview, we're going to see how that works in Los Angeles in the next few months with the O.J. Simpson trial, because certainly there's been no more publicity on any criminal case that I can think of than that one.
One of the issues in Nebraska was the Nebraska Press Association versus Stewart case that went eventually to the United States Supreme Court, that involved some of the court closing information. Does anything that relates to that case come to mind in terms of the historical development of freedom of information in the state?
Well, it was certainly a landmark, as you know, and it was the case, I think, that brought about the establishment of the coalition we call Media of Nebraska, which is a coalition of print and broadcast people who came together at that time to share the costs of having to carry that case all the way to the Supreme Court, and then became a permanent group, which now and these days is kind of a watchdog group in terms of watching the legislature for legislation that's coming up that might affect the media.
Now, for the purposes of our discussion, can you recall the kinds of things that took place there as the issues of the Press Association? It's called that, of course, the Press Association because that was the first name on the list. It consisted of the Broadcasters Association, the wire services, many radio and television stations, the journalistic groups of both a regional, a local, and national level.
Mm-hmm. Well, you know, what happened there was a Nebraska judge who I talked about closing preliminary hearings, and I didn't mention gag orders, but that's another facet of it. Was trying to impose some of those things in a very high-profile case, and the media in Nebraska resisted it and carried it through the state courts, and as I said, it went all the way to the Supreme Court. It was it's in all the law books now, and it's a classic example of the media resisting a local judge's effort to I guess assert the Sixth Amendment over the Second Amendment.
When the material happened in terms of that kind of a situation, in that case was in the middle 1970s. Mm-hmm. In your experience, looking from the period of 1948 through the present, are there other cases that have been that significant as far as broadcast journalists are concerned, or is that primarily the case of significance because it dealt with many issues of all print and broadcast journalism? Mm-hmm.
Well, that certainly is the one that stands out. You know, I can't think right now of any specific ones. And there are these little brush fire things, and as I said, that we constantly are battling. It seems like, but no, I guess I can't think of anything that monumental that went all the way to the Supreme Court.
When that case was decided, which was decided against the gag order issue, and essentially for the citizen or media position as opposed to the defense or prosecutor position there, how did that affect future cases when they came to the courts and they asked for gag orders?
Well, again, it was one that could be cited by the media, and that this one had been decided by the United States Supreme Court, and we don't see a lot of gag order efforts in Nebraska. In my recollection, it's more the efforts to close preliminary hearings. There may have been a few efforts since Stewart to impose gag orders, but I think it pretty much shut it down in the state of Nebraska.
In terms of the cameras in the courtroom kind of issue, in this state, as you know, it is the appellate courts, the state Supreme Court and the Court of Appeals that are open, but not the trial courts. What's the issue in terms of the appellate courts being open versus the trial courts? What's the argument, at least?
Well, you know, the state Supreme Court, again, as you know, working in conjunction with the new appeals court, new at this point anyhow, agreed to use the same rules, apply the same rules as apply to the Supreme Court to the appeals court in terms of allowing camera and microphone access. At the state court level, the arguments pro and con are that to cover an actual trial, again, all the old bugaboos are raised about the impact on the rights of the defendant and the impact on the rights of the public represented by the prosecution, and what effect cameras and microphones actual coverage will have on the carrying out of justice in that case. That's because that is an actual trial, and they are concerned about juries, which is an element that you have in the trials that you don't have in the appeals process or at the state Supreme Court. So it's, you know, the classic arguments that in order to assure a fair trial, many judges in the state of Nebraska, with some notable exceptions, still say, no, I don't want cameras in my courtroom because they poison the judicial atmosphere. And there are a lot of prosecution and defense lawyers who accept that. There are some, as I said, with notable exceptions, who would argue the other way. And our role, again, as you know, has been at every opportunity to demonstrate that we can do this, and without it affecting. And we've had in recent times about a 2 or 3 year experiment, I believe, with audio only coverage of the state courts in certain judicial districts. I think three judicial districts in Nebraska, which was effective and which worked well. Perhaps wasn't as used as often as we might have liked, but it was, when it was used, it worked well, and it showed that we were not an imposition on the judicial system. So we're hoping that now, again, at this time, to build upon that and to convince the courts and convince, first of all, the Supreme Court, which makes these decisions, that we need to perhaps move that experiment to cameras as well as audio devices, and perhaps make it semi-permanent.
You've discussed the Media of Nebraska Consortium, and for the purposes of our discussion, probably we should go into that a little bit more. Please give us a little bit more information about who's in the Media of Nebraska and how it works.
Well, it's the Nebraska Broadcasters Association, for example, is a member of Media of Nebraska. The Nebraska Press Association is a member. The state's 2 major newspapers, the World Herald and the Lincoln Journal-Star, are members of that media coalition. And then there's a representative from from the smaller newspapers in the state also. The executive director of the Nebraska Broadcaster, Dick Palmquist, at this time is vice chair of that coalition. And basically how it works is, I say, they work with a lawyer and a lobbyist in kind of a watchdog role in terms of legislation. Not so much in terms of daily violations of any of our rights to access, although that's a concern, and at the present time there's a plan to try to work with the Attorney General to see if some things can be done along those lines, and that's another question. But its role for the most part is keeping an eye on what happens in the legislature when from time to time somebody is trying to pass some legislation to restrict access in the state.
How effective is it in your judgment as far as broadcasters are concerned?
I think it's been effective. I think the fact that we are in reasonably good shape in the state can be attributed to a large extent to the work of the Media Nebraska Coalition. It's an example of where print reporters and broadcast reporters have come together in a common cause and accomplished something that can make a difference to the public. As I said, sometimes the public doesn't really recognize that those arguments are being made in its behalf. But I think it's fair to say that there are very few legislative sessions that go through without some kind of legislation being contemplated or actually introduced, which would affect public access to public information. And the Media Nebraska Coalition is, with its lobbyists and with its lawyer, is always there to resist that.
In your representation of the broadcast journalists of the state and Nebraska Broadcasters Association, have you come across issues that are somewhat different between print and broadcast journalists as First Amendment issues in the context of the media of Nebraska?
Well, the print reporter is not all that concerned about cameras in a courtroom, and not in the same sense that broadcasters would be. A print reporter would, if permitted, have a small noiseless camera in the courtroom, as they do in states that permit that in their state courts, and take some pictures in there. But television, the picture is part of the storytelling process, much more so than it is for a print reporter. The visual, it's a visual medium, and it's as important as the audio or in the written word in terms of demonstrating or reporting, to use that word, what is actually going on. So I think that's the basic difference. There would be, I must say that in this state anyhow, the print medium has certainly been supportive of a broadcaster's efforts to get fuller access to the courts, but it's not as critical to them, I don't think, as it is to us.
There is a voluntary code in this state, maybe code is perhaps not the right descriptive word, but call it the Bar Press Guidelines. How do those fit into freedom of information in your judgment in terms of broadcast news?
Well, the Bar Press Guidelines came into being again, I think, as a part of the Media of Nebraska organization and part of the maybe an outgrowth of the Simons case. They impose upon is not the right word, because these are absolutely voluntary. They are a set of guidelines that the media and the bar agree to on how criminal cases should be covered, and what kind of access should be given to all of the media, the rules and the regulations under which The lawyers should operate, and the same for how the reporters ought to operate. They are voluntary, and there have been cases where certain media groups have not observed them as they should, perhaps. But then there's certainly been cases where the county attorneys or the defense lawyers haven't observed them either, and that's an example of what I spoke about earlier, where sometimes in a smaller community, for example, they're either unaware of the bar press guidelines or just choose to ignore them.
Let's turn from the judicial system at this point and look at the issue of public records. There is a public records legislation in the state which allows access. How does that fit into the coverage of broadcast news in the developing period here through 48 through the present?
Well, public records are vital to the day-to-day coverage of news. In order to, whether you're a print reporter or a broadcast reporter, in order to get information about what's happening, either in a court case or in a matter which is in a city council, city government, county government, state government, there are records which, by law, are open to the public. So that's how it comes into play. A good reporter always has to go follow the paper trail, as they say, to get that kind of information. The problems which have existed in terms of access is the definition of a public record, the interpretation of it by various agencies of government, the efforts in recent times to increase the costs of obtaining it. The state, for example, would like to charge perhaps double or triple the charges of running off copies of things, and of course that makes, we're particularly a small news organization, that makes it more difficult to get to those public records. So again, in terms of the public's right to know, it's extremely important that a reporter be able to go right to the public record and get the information there without an overly burdensome cost to it.
As a reporter, before you became a news administrator, but also as a news administrator in charge of reporters, how has the climate of public officials been in terms of allowing access to public records?
It's I think it's changed, sometimes for the better and sometimes not for the better. I can recall, as a young police reporter, having much more access to certain information than apparently is now, and I haven't done any police reporting obviously for years, but then from what I understand is a situation now. We were able to walk right into the detective bureau and sit down with the chief of detectives, and he would hand over his reports to us, and unless he got up on the wrong side of the bed that morning or something. In other words, the relationship between the reporter and the news source was much easier, I think. It used to be that you could just go in and sit down with a guy and he'd talk to you and you'd come away and you'd have your story. Now I think it's much more complex. On the other hand, it's the pluses, I guess, is that perhaps there was information, and I say this quite honestly, perhaps there was information in those times that shouldn't have been released. We could, for example, go up to the jail and they'd haul a prisoner out of his cell and stand him up against the wall and let us take pictures of him. That's not permitted anymore, and I think maybe that's just as well, because sometimes you were taking pictures of a guy who was being held and who later was not convicted. So you were doing him an injustice, and perhaps that's a rule that needed changing. So it's kind of hard to answer that. I think it's certainly changed, and things were much more casual 40 years ago. It was easier to get information. It's tougher, I think, to get the information now, but I think by and large, I think it's just being done in a different way.
There's another piece of legislation called the Free Flow of Information Act, otherwise called in the colloquial terms the SHIELD Law. How does the SHIELD Law fit in terms of your perception of freedom of information in Nebraska?
Well, the SHIELD Law says that a reporter cannot be required. I'm going to paraphrase this, but cannot be required to testify in court, for example, about information he has as a result of his role as a reporter. And it also says that they cannot have access to his raw notes that he took in the course of his coverage of the story. Can only have access to anything that was actually aired, either television or radio or print, as far as that's concerned. So that's been an extremely important, and by the way, Nebraska SHIELD Law is one of the better ones in the state, in the country, I think. It's been an extremely important tool for reporters in this state, because there are frequent efforts to subpoena reporters to testify on what they know about something, and the SHIELD Law stands there, as the colloquial term says, as a shield to prevent them from requiring that reporter to do that.
What about the issue of the video materials that are sometimes recorded in a television station as a part of the reporter's notes process? How has that evolved in your experience as a television news journalist?
The video, tell me more about what you're saying.
Well, and we often talk about reporters' notes in terms of a SHIELD law, but in some cases what's really interesting to somebody is the video recording that the reporter, or perhaps the reporter videographer, got in terms of a particular set of circumstances, and a member of the legal team or the police would like to have the video as opposed to the notes.
No, that comes under the same category as the notes, because unless it's been aired by the material, then is the raw material, and it is protected by the SHIELD law.
Have you had requests for that sort of information?
Oh yes. Over the years, we had many, and I'm sure that still goes on, many instances where they would ask for not only, well, you'd get a subpoena, and then there's always the question about, as the lawyers say, how narrowly drawn is it? Because it would be a fishing expedition, and they want everything you did on such and such for the last 10 years.
Where does this come from, this fishing expedition?
From one of the lawyers, quite often the defense lawyers, because what they're looking for is, they're fishing. They're looking for some information that might be useful to them. But, we working with our own lawyers and with the Media Nebraska lawyers, we just resist anything which has not actually been aired, and then it has to be obtained by subpoena. And we just don't turn over our newscasts to any government entity, because it's material which the government can have only under subpoena, and only material that had been aired at some time.
Now, putting this in perspective, would you say that this is a situation which is a slowly rising curve of interest for these kinds of requests, or is this something that peaked at a particular point and is declined at a later point, or it's an up and down? How would you characterize the request for outtakes and reporters' notes from the fishing expedition type of request?
Well, at this time, as you know, I've been retired a little over 3 years, but at the time that I was still running a news organization, at that time I thought it had increased, and I think maybe that has continued to grow up, and I think that's a question of sophistication too. I think that the defense teams quite often have become more aware of how valuable some of that kind of material could be to them, and it's more of a sometimes it's more of a harassment, but you'll find that maybe several times a year, while you'll get one of these overblown subpoenas and saying they want everything that you did in the last 10 years on such, and that didn't happen That didn't happen 20 years ago because, for one thing, they were aware of the fact that before videotape, that material didn't exist anyhow, because you had a certain amount of film that was saved for a while, but it was not as useful to them as videotape.
As you look at some of the background, some of the changes that have come about in some of the legislation, talk about some of the names of individuals that come to mind that are important in terms of freedom of information, both broadcast journalists, print journalists, politicians, people who, in your judgment, helped move the cause of freedom of information in the direction of freedom.
Well, there have been a lot of people, and as I said at the outset, there are people even today who are fighting the battles down in the trenches who go nameless, who perhaps need some acknowledgement. But certainly the name of Frank Fogarty comes to mind, who was the head of Meredith Broadcasting here, and was the general manager of WWT or WWTV at that time for many years, and was always active with the Nebraska broadcasters in freedom of information issues. There's certainly my late colleague Jim McGaffin, who followed Fogarty in that activity, and who was very much, he was involved in the Simons case and the Stewart thing that we talked about earlier.
Nebraska Press Association versus
Nebraska
Stewart
Press
involved the
Association.
Simons issue, yes.
Right, and that was, I know that the Jim McGaffin was one of the people who was very active in that one. I think people like Bob Spire, the late Attorney General, who was very active in helping media people obtain, and I guess what I should say, Bob Spire was active in seeing to it that lawyers and judges in the state understood what the law says. There have to be many others, Larry, but as I sit here, I can't think of a lot of names right now.
When we talk about the issues of the freedom of information, and we talk about the public awareness, and we talk about the media awareness, you've alluded to this in terms of part of the conversation, but I'd like to focus on it a little bit more in terms of the evolution of television as a news gathering force in society. And I'm wondering, from your particular perspective as a person who was essentially a classically trained reporter who worked in radio for a period of time, who worked in television in the early days, how you think that television has contributed to or worked against the public's concept of freedom of information.
Well, it's done both in a way, I guess. It certainly has raised public understanding of what's possible, what can be done. At the same time, there is this rising crescendo nowadays, as you know, that the media have gone too far. And so I think the public sometimes doesn't understand why we operate the way we do, how we operate the way we do. You have a generation now that's been raised on television and expects it to be able, of course, to do live shots from the moon or anywhere else. My generation, I guess, was raised on newspapers, and I've seen what the miracle of television can bring about, but at the same time, I can also philosophically accept some of the misgivings that people have about television being too obtrusive, being people will criticize you for wringing every bit of emotionalism you can out of a television interview, and you do see that sometimes. I think you see less of it now. I think that television reporters have become more conscious of the fact that
they were doing it. I think in the beginning, as I said, we kind of invented the business. They did things that they were not aware of what the public impact was. But you know, it's if your question is, does the public appreciate what we do? I think that subliminally they do, but the last time I saw any figures on it, we were somewhere in the category of used car salesmen as far as public affection was concerned.
Let's talk about the role of what sometimes is called participatory democracy, where we want people to vote, we want people to pay attention to issues, we want them to express their opinions and have some rapport with their elected officials. How does television news play a role in that?
Well, I think it certainly ought to make people more aware of the political climate, aware of the need to participate. I can't sit here and say that we have. You look at voting patterns, and I don't know that people vote any more frequently now than they did 40 years ago, or any more intelligently than they did 40 years ago. So I don't know how successful that's been. I think that the information is certainly there for them through television, radio, print. People confuse television news reporting, of course, with everything else that happens, with the commercials, the television commercials, which are widely criticized, you know, in terms of whether they're negative or positive, and those are terms that are hard to identify too in terms of a political commercial. But I don't think people make distinctions between what a reporter tries to do in reporting a political story and what he or she sees on a commercial. They kind of just blanket it by saying, well, that's all television. So I don't know if that's the answer to your question, whether it is improved public participation. The potential is there for it, but I don't know if there's evidence yet that it has.
You have the advantage of being an observer of Omaha, observer of Nebraska, observer of broadcasting for a substantial period of time, a period of great change. Rank for me the level now of freedom of information available to the public now at this time in the last few years compared to when you started out.
Well, because of technology, there's much more information available. As I said, when I first started out, it was a more casual time, and it was sometimes easier for a reporter to get certain information, but he didn't have the tools to disseminate it like he has now. You know, you had to gather information and then walk or catch a bus, or if you were lucky enough to have a vehicle, get back to the station somehow and write the story and get it on the air. You know, and all of that was a time-consuming thing that has been done away with by live reporting. Of course, live reporting has its own snares, but I think by and large the availability of public information now with cable channels, what were we talking about, 500 cable channels, is much superior to what it was when I started.
For you as an individual who had a lot of leverage, a lot of leadership influence, tell me how much you personally pushed freedom of information as a news director.
Well, I think as a news director, I tried to push it in my own shop, obviously, by being sure that the people that I worked with were aware of what their rights as reporters were and what the restrictions on them were as reporters also. And then beyond that, I tried to do what I could by participating in organizations such as the Nebraska Broadcasters and the RTNDA, SPJ, Society of Professional Journalists,
and then my daily contact with people in the public who might be in a position to help forward the concept of public information.
That's two different sets of circumstances. They're both interesting, but stay a little bit in terms of being the news director. The issue is a key individual in the role of news director can do certain kinds of things that bring certain kinds of issues to bear.
Well, he can, in terms of dealing with his own staff, is that what you're talking
Yes,
about? Sir. Okay. He can be sure, again, that his reporters know the bar press guidelines and are following them carefully. He can be sure that they are not, that they are knowledgeable about what the state law says as far as what their rights are concerned, what their rights are. He can resist, as I said, the overblown subpoenas that aren't narrowly drawn and are an effort to, a subpoena can be a frightening thing. The first time you ever get a subpoena, the receptionist calls you and says there's a deputy sheriff out here and he's got a subpoena for you, and your name as the news director is on it. Well, the first few times that happens to you, and particularly if you're an inexperienced guy, you tend to panic. It's kind of scary to get a subpoena. How many average citizens in their lifetime ever get a subpoena for anything? So you learn to resist what does not. You recognize with the fishing expedition, as I called it earlier, and quite often you have your own company attorneys that you can work with and help you on those kinds of things, and hopefully your attorney is one who is aware of all of what the public information laws are and is supportive of you.
Let me phrase it this way. The philosophy, I think, for a number of years is, when you were the news director of the Channel 6 operations, was Steve Murphy is a great leader of freedom of information. If I'm a reporter or I'm a photographer and I want to push something that has freedom of information, I know that I will be backed by my news director and by the station management.
Well, that's absolutely true. I hope I had that reputation. I hope I did.
So are there times when the news director says, go out and follow up on that story because I want to know, I think we should deal with that, and you just plain push the freedom of information issue?
Oh, certainly. You're going to ask me for examples, and I'm sure there are. I can certainly cite the late unlamented Franklin investigations here in the city of Omaha, where the dilemma was avoiding the wild rumors that were abroad in the community, where you had to police very carefully what your reporters were picking up and what they were bringing back, because there was so much potential there for doing harm to the reputations of certain private citizens, and at the same time fending off the hundreds of phone calls and letters from people who somehow thought there was a massive conspiracy among all of the media in Omaha to hide what was going on in what turned out to be, as the grand jury called it, a gigantic hoax. So the freedom of information mantle, if that's the word, has to be worn with some care in terms of not always out there asserting your rights, but recognizing the fact that there are other elements in the community that have rights also.
How did you get the opportunity, the willingness to go out and take the mantle beyond the station and get into the industry leadership?
Well, I guess my mother never taught me to say no. No, I had a personal interest in it, and when people would come to me and say, would you like to serve on this committee or serve on that committee, because it was something I had certainly a personal interest in, obviously I did it. It's like somebody who likes to play golf or bowl. I didn't do a lot of golfing in my time, but that's another question.
How important are groups like the Radio Television News Directors Association on the national level or the Nebraska Broadcasters Association on the state level? How important are they in the freedom of information process?
Oh, I think if they didn't exist, we would be in much worse shape. I think that you need an entity, particularly before the legislature, particularly before in arguing before the courts, which is not just the individual reporter. You know, the individual reporter or news director is a small voice in the wilderness. He needs the support of an organization at the state level like the broadcasters, and certainly at the national or international level is the radio television news directors, which is, as you know, a very effective organization in terms of working in Washington and lobbying in Congress for freedom of information questions.
Looking at the future, what's left to accomplish in freedom of information? What still do we need to accomplish?
In Nebraska, I guess maybe the primary one is to get fuller access to the courts for our cameras and our microphones. I think to eliminate the what I call brush fire situations, where a lot of small community attorneys and law enforcement people are ignoring or not aware of the needs and of what the law says as far as reporters are concerned. The law is there. You know, in the state of Nebraska, the law is there. It's just what we have to do is to see better observance of it on both sides.
What's the best way to accomplish that?
Constantly pounding on their doors. You know, when these people call me, as you asked me earlier about what to do, I tell them they have one of the best tools right there at their hand, and that is to go on the air and say, Sheriff so-and-so went fishing, and so I can't get the information on that double murder this morning until he comes back to town. Well, after a while, the public in the community is going to say, what's the sheriff doing fishing when he ought to be investigating this murder? So I think that media people, reporters, ought to use the tools of their trade more to fight their own battles.
This has been a conversation with Steve Murphy, as a part of the Nebraska Broadcasters Association, interviews of Hall of Fame members, where our conversation primarily has been discussing the freedom of information issues because of Steve's work as a freedom of information chairman for the association. He's a member of the Hall of Fame. He's a member of the Nebraska Broadcasters Association Hall of Fame, the Radio Television News Directors Association Board of Directors. He's been the Journalist of the Year for the Society of Professional Journalists, and I suggest to you that without his leadership and his concern, the citizens of Nebraska would not have as much freedom of information as they have had and enjoyed in the past. Thanks, Steve.
Thank you, Larry.